Okay, so hello everybody. Welcome. My name is Denise Mashmasarmi. I am the Associate Director for the Center for Inclusive Excellence. My pronouns are she, her, hers. And so thank you all for joining us today for our immigration status, navigating college and beyond. Today we have Megan Gibbons and Dayanna Moreno here with us, who will be sharing great information, resources, and tips for students who are starting their college journey, currently in their journey, or looking toward graduation or the professional world. And so I'm going to turn it over to our two guests today to introduce themselves, and then we'll jump into Megan's content.
Well, hello, my name is Megan Gibbons, and I am the director of our Center for Global Connections. So in the Center for Global Connections, some of the work that I do involves overseeing our students on campus who are interested in studying abroad. But what brings me here today is the fact that I also oversee and advise our international students who are coming to Regis to study in the US, so our F1 visa holders. So the Center for Global Connections is intended to provide resources to our international students on campus, support advising, and answering questions that they have about their status as they progress through their academic program. So I'll be focused today on that F1 visa experience. I've been at Regis for just over a year. My own work in international education has been ongoing for many years. And I've got background in Spanish language, and I've done a lot of international traveling myself. So I'm really excited to join you today, and thank you for the invitation.
My name is Dayanna Moreno, and I'm the Director of Legal Services at the Greater Lawrence Community Action Council. We help low-income and indigent immigrants by providing legal representation. I've been working in immigration for about 10 years as a specialty, and I am an immigrant, and I was once an undocumented college student, and it really both made me afraid to practice in immigration, and then eventually became the reason I practiced in immigration once I graduated from law school. So I hope to share with you guys kind of some of the changes that have occurred so far, and kind of what options as such exist for people in different statuses, and answer questions in that kind of thing.
All right, well, we'll get started then. So I'm kind of focusing, as I said earlier, on understanding your status as an F1 visa holder. And I thought we could start today by defining some of the terms that we're going to be using. I understand that much of the language that's related to an F1 student on campus is very specific, and it's used by a small group of people, really. And so I think it's always a good thing to sort of understand the terms that we're using first, and then I'll provide more of an overview of the process. So I wanted to start with non-immigrant status, and specifically non-immigrant and what that means. And essentially here, the key word when we talk about non-immigrant is temporary. So we're talking about individuals who enter the US with the intent to leave after their work or study has been completed. When it comes to F1 visa, that term F1, what does it mean? What is the F for? And essentially there we're talking about a visa category. So F is a visa category. And specifically F refers to academic students. So these could be high school, college, university, even students in language training programs. So if you are the student who's requesting the visa and you're traveling to study to the US, that one refers to you. And if you happen to be bringing children or dependents, other family members with you, then they receive the number 2. So they would be on an F2 visa. So next up is the Student Exchange Visitor Program, or the SEVP, right? So there are a lot of abbreviations and acronyms in this world too. So the SEVP is the organization that manages both the students and the programs. So the F1 students, the F1 programs, they manage these programs on behalf of the Department of Homeland Security, or the DHS. Now, the organization, the SEVP, has a specific database system that they use to store information and keep track of all of the records that are created. So the Student Exchange Visitor Information System, or SEVIS, right, is the system that they use to manage the records. I'm mentioning U.S. Citizenship and Immigration Services, or the USCIS, in part because they're going to play a critical role in OPT applications for an F1 student later, and I'll talk about OPT in a few minutes. But the USCIS is critical when it comes to off-campus employment, essentially, in certain cases. And I'm ending the list of terms today with perhaps the most important, because it's the designated school official. So a designated school official is someone who communicates with SEVP. It's the person on campus who is going to update the student records. And it's the person who will be helping that student maintain status while they're on that F1 visa. So in this case, at Regis, we have several DSOs, and I serve as the PDSO, which is the primary designated school official. So now that we have some of the terms cleared up, I wanted to provide a general overview of the process, kind of quickly from start to finish, of an F1 student's journey to a college campus, right? And this process begins with what is called the I-20, right? So you're accepted to Regis. You've decided you want to attend Regis. The next step is that Regis and a DSO, someone like myself, would reach out to you and say, okay, we need to create an I-20. And that is a certificate of eligibility for non-immigrant student status, right? So that's why I led with non-immigrant. In order to create this certificate, the I-20 for you, we have to request some basic information, and that includes things like date of birth, your place of birth, home address, US address, etc. The piece, though, that's often a bit more complicated is that we are required to also request documents that can show that you have financial accounts able to support you for an entire academic year. So before we can issue that I-20 to an F1 visa, potentially an F1 visa holder, we have to have proof of finances for an academic year. So that could be your own bank account, could be family bank account. You can have someone in your family sponsor you. And so it's collecting bank statements and other things to show that you can pay the expenses for an entire year's worth of study. That is a burden. I recognize that. That's a burden that's not placed on domestic students. But that is something that's required of us as DSOs in order to create that document. So once we've created the I-20, the next step in the process is to pay what is the 901 fee. And essentially that's a fee that goes to support the SEVIS database system, and it's a fee that's collected by the SEVP, right? You need certain information from the I-20 in order to get online and pay that fee. But once you've paid the fee, you're able then to apply for a student visa. which would require, in many cases, an additional visa fee and an in-person interview at an embassy. When you've secured your F1 visa, you make your travel arrangements to arrive in the US. And most typically, we would ask, if you're starting a new program, that you arrive no earlier than 30 days before your program start date. And that program start date is clearly indicated on your I-20. So when you get to campus, one of the first things that you should do is, and you need to do, is check in with the DSO. It's called reporting. And when you report to the DSO, then they indicate that you have arrived, you're prepared to start your academic studies. And if you had been in what's called initial status, you're then moved to active status. So I want to pause here to talk a little bit more about the importance of establishing a relationship with the DSO. This would be my first tip, right, for today, in the sense that the DSO is going to be critical in terms of guiding you through various stages of the process. When you perhaps want to get a driver's license, when you want to get a social security number, if you've secured employment of some kind. But specifically too, with regards to the academic progression through your degree. So if you were to change a major or change your program, that's a conversation that you would have with the DSO, because it would require going back into CVIS, remember that's the database, and updating the record. So there's a long list here of things that you should discuss with the DSO before you actually, right, do any of these things. So changing your education level. If you were to transfer, it would be the DSO who would transfer your record from Regis to wherever you may be headed. If you were moving to a new address or changing a name, all of these things are things that would require updating your record in CVIS, and so therefore you need the cooperation and the support of the DSO. The DSO is intended to be somebody who can help you through these processes and answer the questions that you have along the way. So from here, what I thought we would look at next is the question that I get the most, and this is related to employment. And essentially, there are two kinds of employment: on campus and off campus. And if we look at on campus first, the basic breakdown is this: you are allowed as an F1 visa holder to work on campus. If you are working on campus during the academic school year, so during spring semester now, let's say, you are limited to only 20 hours of work per week. However, if it's a vacation period, you then are allowed to go up to full-time working hours. Okay. So the first time that you want to engage in on-campus work, it's a good thing, one, to speak to your DSO. You're going to show the DSO a letter from whichever unit or department on campus is looking to hire you. So you bring a letter. That letter then can be used later when you want to secure a social security number. The good thing about working on campus for many students is that it doesn't require approval from the USCIS, right? And that means that there are no additional fees required for you to pay in order to be able to work. So there are some more restrictions and guidelines that are a little more specific related to on-campus work, but the basic idea here is that you may work on campus. You do need to work through the DSO in order to get that process in motion. And you are able to actually work, if you needed to, you could work multiple jobs on campus as long as your hours don't exceed 20. When it comes to off-campus work, there are really only 3 occasions where you're allowed to work off campus as an F1 visa holder. And the 3 are economic necessity, curricular practical training, also called CPT, and then optional practical training, which is called OPT. So I'm going to take a little closer look at CPT and OPT in a minute. But for the economic necessity, essentially, SEVP sort of defines this by saying, if you have lost your means of income, for instance, maybe you had an on-campus job, you lost it due to no fault of your own, and that significantly impacted your ability, right, to continue to support yourself, that could be considered economic necessity. They also mentioned things like a decrease in value of currency, perhaps from your home country. If there are medical bills that aren't covered by insurance, all of these things, there's a longer list, but these are some of the examples they provide for, economic necessity. The unfortunate piece here is that in order to apply to work off campus, because you have an economic necessity, the application itself is fee-based. And so there's a fee that you pay to get started. Now you can request a fee waiver. And again, that's something that could be discussed with your DSO and should be discussed, and you can certainly apply for that off-campus authorization to work. And it's not always, the other piece here that's unfortunate is that for the economic necessity, these aren't always granted. They're not always approved. But when we move into the next 2, the CPT, let's go to CPT next. I want to sort of highlight some of the differences between these type of off-campus employment opportunities. So first of all, for CPT, curricular practical training, it's managed through SEVP. And that's important because that's connected to the 4th point there. There are no additional fees, right? Now, the work that you do in this curricular practical training must be related to your field of study, and it must be integral to your degree program. So in some cases, if we're talking about nursing and clinicals and those clinical hours that are at an off-campus site, some of those, if it's required of your program to be working off campus, then you have to request CPT in order to do so. That request goes through your DSO. The DSO says, okay, yes, you're approved. This is all of you, you tick all the boxes here in terms of eligibility. Then a recommendation is made on your I-20, and you're able then to work off campus as part of your degree program. So we do have, and I've worked with several students already at Regis who have engaged in CPT, right, as F1 visa holders. So then there's OPT. Now, this is a little bit different in that the decision here lies with the USCIS. They're ultimately going to decide if you're approved to work off campus for OPT. So just like CPT, the work that you engage in must relate directly to your field of study. You can begin to work off campus before you complete your degree program, and that's called pre-OPT. Most people actually work off campus after the completion of the degree program. It's called post-OPT. But there are cases where a student has a really great job opportunity after having done an internship, and they want to get started. They don't want to miss out on that opportunity, and so they might apply for pre-completion OPT. If you do use that route, you only have 12 months of OPT per degree level. There is an exception for the STEM fields, and I'll speak to that in a minute. But let's say you start working and you use some of your pre-completion OPT, you have to keep in mind that altogether, pre-post, you'd only have 12 months of eligibility. So this requires a much lengthier application process. It's much more involved than the CPT, which is usually one piece of paper, one form, and a conversation with the DSO and your academic advisor. The OPT requires the completion of the 765, and this is the application for employment authorization. So as part of that application, you have to pay some additional fees. Currently, that filing fee is $410. You send in the copies of a lot of your F1 records, including a copy of the I-20, photos for what will become an employment authorization card that you receive. And when you reach this point of the process, we have prepared at Regis documents that sort of step-by-step guide you through filling out the OPT application, the address of where that needs to be sent, how to properly address the check or to pay the fee through money order. So we've got a list of resources and documents that are already ready to sort of help you through. And of course, you can always arrange for in-person appointments when we're able to do that again, or a Zoom virtual appointment to sort of step by step go through the process and make sure that you've done it correctly. I should, before I get to this next slide, go back to the OPT with regards to STEM. So if you do have a degree, and there's a very specific list of STEM degrees that are eligible for what is called an OPT extension. So an OPT STEM extension allows you to work for an additional 24 months beyond your initial OPT placement. So again, your DSO would have a list of those STEM fields that are approved for that. And that is something that you may or may not wish to pursue given your degree and your work choices and preferences. So once you get your diploma, once you've made it through your degree program, what's next, right? There are different options, right? So if you haven't used your OPT and you'd like to work in the US, if it's applicable, you can certainly start OPT. You can start working, spend another 12 months in the US. And if you, again, that's by degree program, right? So if you've completed a 4-year bachelor's degree, you're eligible for those 12 months of work in the US afterwards. But you could also begin a new program. You could accept an admission offer for a program elsewhere, or maybe even at Regis if you wanted to, if you had a bachelor's and wanted to progress up to a master's. That's called a change in education level, and that's certainly allowed. But you do have to do that within 5 months of having completed your first program. There's also the possibility of applying to USCIS, again, Citizenship and Immigration Services, to change your class of admission, so to change your status. That's a third option. And then as a fourth option, you could consider travel. Once you've been in the US and you've maintained your eligibility as an F1 visa holder, you've completed your degree program, you have 60 days after the completion of the program to depart. Remember, this gets back to that idea of non-immigrant, and once you complete the program, you're going to depart the US. But you don't have to leave immediately. So in that 60-day grace period, if you wanted to see a different part of the US, or just simply have the time to explore the areas that you didn't get to see while you were studying, that's an option that's also available. So I'm going to pause there and let Dayanna take over at this point. And I'm hopeful that this has generated maybe some thinking on your part, and you might have other questions, but hopefully you've got a better understanding of who's involved and the process that's involved in sort of maintaining your eligibility from start to finish, and some options you have post-graduation.
Hello. I apologize for maybe it's not bad that the presentation that I made for this I cannot access from this remote office, but I'll just share some pictures so you don't have to stare at my face the whole time, if that's okay. So like I said before, my name is Dayanna, and I am the Director of Legal Services at the Greater Lawrence Community Action Council. And I wanted to talk kind of about the non-student and or work-related visa topics. So first I wanted to talk about the changes that have occurred so far in the administration. And the easiest place to start is there aren't that many changes. I think that there's a lot of talk about the changes that this administration may be undertaking. And there's a lot of talk about the changes that they want to take and so forth, but very few changes have actually taken place. But I'll review what those are. The biggest are at the border. So most of us that are already here, so if you're already watching this presentation from here, from the United States, then you're likely not very affected by the changes that have occurred at the border. But those include things like the Migrant Protection Protocol, which is a heinously named program, which kept people on the Mexico side and metered their entry into the US, is being done away with, and just providing people the ability to seek refuge at the border, to seek asylum. So that's one of the biggest changes, but it occurs mainly at the border. One of the biggest changes inside the border is the change to enforcement priorities. And so what that means is that the administration has said that they will prioritize enforcing orders of removal for certain immigrants. And that's was actually kind of newish under the Obama administration. So before the Obama administration, it was kind of, if you're here and you're out of status and we caught you, then you would get, removed if you had an order of removal. And the Obama administration, in this new era of immigration that we're in now, that started about 1997, they were really the first administration to say, we're going to prioritize these enforcement actions. And if you have an order of removal, but you have family in the US and you don't have, you're not a criminal, this kind of thing, then we will deprioritize removing you. But that was actually fairly new to kind of immigration under the Obama administration. The prior administration obviously went hard in the other direction. And this administration is going back to those enforcement priorities we were familiar with. So they're enforcing removal for newer arrivals, so people who arrived after November of last year, people with certain types of crimes called aggravated felonies, which are a term of art in immigration. So a crime doesn't have to be a felony to be an aggravated felony under immigration law. So it's a specific kind of list of crimes. People with suspected gang involvement and people who are a threat to national security are the people prioritized for removal, and then others are deprioritized for removal. Another big change within the border is the change to the public charge rule. So the public charge rule has always existed since, again, the era of immigration that we're in now, that started in about 1997, already included a public charge rule, which means that if you were a risk for being a public charge to the United States, meaning that you would be dependent on public assistance for your support, then that would make you inadmissible, right? And ineligible to live in the US. So that rule already existed. And what the administration did is changed how they would make that determination, the prior administration. In the past, if you had a sponsor who could show they had enough income to help support you if you weren't able to support yourself at 105% above the federal poverty level, then you were admissible as not being a public charge risk. And if you couldn't have such a sponsor, then you weren't. And that was kind of it, more or less. And so this administration kind of started to came up with this whole list of factors, including age and language and level of education, and zeroed in on whether you had used any public benefits. And so this created a lot of fear in the community, and people being hesitant, of course, to use public benefits. And so that rule has been reverted to its original kind of enforcement. The other change is that any regulation that hadn't started yet, so toward the end of the administration last year, they passed a bunch of new regulations or changed regulations that were already existing mostly. And so ones that had been through the public comment period, et cetera, but had not yet been kind of instituted, those were put on hold. And then the agencies, kind of all the federal agencies, were asked to take 90 days to review all the new regulations. So those regulations that the prior administration was able to change, to review all those to see which, if any, they should keep or not keep. And that's the gist of the changes for immigration so far. And so, not a lot of things that affect people already here. Enforcement priorities only affect you if you have an order of removal. The public charge issue only affects you if you have a relative or employment-based petition kind of pending for you, and so forth. So not a lot of changes, not as much as you would think if you listen to the news, I guess is the point. And so the reason I think we're hearing all this noise, other than we're all very hopeful, is that there is legislation proposed for immigration reform. And I try not to be a super bummer, but I do temper my excitement for this legislation because I've now been practicing immigration law long enough that I've been promised, I believe, 2 immigration reforms that I have not received. And so it's hard to get super excited that immigration reform is coming if you've been super excited twice already that immigration reform is coming. But it's probably worth getting a little excited about. And there's a lot of information out there from, for example, ILRC or AILA, the American Immigration Lawyers Association, about what is or isn't in this legislation. And if you're very curious, you can dive in there. But I wouldn't invest a ton of time reading what's in this proposed legislation, because obviously it'll go through Congress and the Senate and all those committees where they have to kind of line up things, and many things will be traded and compromised in deals if we are lucky enough to get reform. And so I wouldn't read it very detailedly and get invested in any of that. But what I do think we can feel fairly confident about is that what the people who are generally called dreamers, like Dream Act types, DACA, that population and that generation of immigrants, are likely to be covered by really almost anything that's going to pass as reform. Also for TPS recipients, the longer term ones, right? So El Salvador's had TPS for, I think, 20 years now. We can expect that those populations will be covered by by new legislation. But other than that, it's definitely wait and see, and don't make any decisions or changes based on whether this legislation is going to pass, because this is not the first time that we have not had legislation reform pass. But the other thing I wanted to add here is that whether or not you're a permanent resident of the US or a US citizen, or in status or out of status, all legislators are still your legislator, right? So everyone who lives in whatever district is a constituent of that legislator, regardless of anything to do with their immigration status. And so I would always encourage everyone to become involved and reach out to your legislator and tell them that you support immigration reform, because it can't hurt. So now I wanted to talk a little bit about options. What are other, outside of this kind of student, the student visa and international students situation, what are immigrant options? So as Megan mentioned, there's like an F1 visa is a non-immigrant visa, just like a tourist visa is a non-immigrant visa. You're meant to be here for a discrete amount of time and then go home. So immigrating means staying here permanently. So what are the options to immigrate? And in the United States, there are, as the law is now, there are only certain ways to do that. And outside of those, there's nothing. If you're not on one of these paths, there's nothing, regardless of other equities. And that's different from a lot of other countries. So I don't know a lot about the laws of other countries, but what little I know, for example, of in Spain, where I have a lot of family who's emigrated to, I'm Venezuelan, so my whole country is in diaspora, and I have a lot of friends and relatives who have immigrated to Spain. And so my understanding is that, you've been there long enough, and you kind of get some way to start to get employment authorization and residency by virtue of kind of how long you've been there and out of trouble. Kind of, we have to do something with these people, and some path to status is provided. There's nothing like that in the US. In the United States, the options are through an employer, which is what Megan talked about. So if you are in status and are sponsored by an employer, then that's one avenue. And that's the avenue I know almost nothing about, but I'm sure that Megan could connect you to someone who could help you with that. The other is through family. So family unity is really big in the immigration legislation. And so if you have a US citizen or resident who's a close relative, so a parent or spouse or sibling, they can petition for you. Depending on what kind of relative those are, right? Which of those things are they? Do you have a US citizen sibling or a US citizen spouse or parent, and how old you are? Are you a minor, which for immigration is under 21 or not? Can decide how long those things take. But for example, the spouse of a US citizen will immigrate, so will kind of complete their whole process pre-COVID in maybe a year or something around that, right? 9 months to 15 months or something. While the adult child of a US citizen will probably wait about 7 years for status because of the backlogs in that category of immigrant. So it's family immigration. And then there's humanitarian immigration. Humanitarian immigration, I think, has this kind of side area of kind of nowhere land, where I think DACA and TPS are. So those are humanitarian type reliefs, but that as of right now have no path to permanent legalization. You're kind of at the whim of it being kind of renewed and not repealed and this kind of thing. And then we all learned in the last 4 years how easy it was to mess with those. And then under humanitarian, for kind of more permanent options, you have asylum, special immigrant juvenile status, UNT visas, and VAWA. And there's there's probably a few other things, but those are really going to be the big ones. And I'm just going to touch on each one briefly. And if any of these ring a bell for you or make you wonder if you might or if it could help or this kind of thing, then the best thing to do is to get a consultation with an immigration attorney. So the first I'll go into is asylum. So asylum is based in international law. It's like kind of you're already in the US version of refugee law. It's kind of all in the same family. And asylum says that if you're fearful of returning to your home country for a reason that is protected by asylum law, then you can seek refuge, right? And it's got all these technical requirements, like you have to seek asylum within a year of having entered the US and things like that. But I still would recommend that if any of these things ring a bell, that you speak to an attorney, because many of those things have exceptions if you can, prove certain circumstances. But asylum looks like, are you afraid to return to your home country, either for something that happened to you there, that happened to you kind of specifically for a reason that's somewhat unique to you, or you fear that would happen? So again, I'm Venezuelan. A lot of Venezuelan immigrants, when I ask them, why did you come to the US? / why did you come to the US right now, right? You didn't come 2 years ago or 3 years ago. Did something happen that led you to come right now? Often I hear things like, it's really dangerous there. Lots of people I knew got mugged, or I was mugged, my car was stolen, my house was broken into. It's very hard to get a job. The pay that you get, you can barely subsist on. And these are all really harrowing circumstances and reasons, very valid reasons that people have immigrated, but none of them are really things that are covered by asylum law, because asylum requires that you're persecuted, right? The fear is that you're persecuted by the government or an actor the government can't or won't control for one of these specific reasons protected by asylum law, which are, things like political opinion, religion, being a member of a particular social group. So, but if that same Venezuelan says, I'm afraid of returning to my country because I'm gay, and and at home it's very hard to be out because I can be beaten in the street for being gay, for example, or I can be fired from my job, or not get a job if my employer knows I'm gay. And so that's why I'm afraid to return to my home country. Then that person is a member of a particular social group. Or I was in the opposition of the government, then that member is of a particular social group. Or I came to the US and now I'm an atheist and my country is very religious. Or now I'm a Muslim and my country is very Christian. Or now I'm a Christian and my country is very Muslim. And I'm afraid that I will be harmed for that reason. And if that's something that actually, is likely to happen, then an asylum attorney can help you file that application and document the danger with country conditions, and that's one option. Special immigrant juvenile status is available to people under 21. So under 21 in immigration, you're considered a minor who have been abused, abandoned, or neglected by one or both parents. But that is under US law. And so if you immigrated here with one parent and your other parent's back home and has kind of been uninvolved and since you came to the US, or even if you're in contact with them, they don't help you financially. That could be very difficult, right? To send money the other way. Then that may meet the state definition for neglect, even though you don't feel like a neglected child, for example. And so for people under 21 who have the support of only one parent or of no parents, special immigrant juvenile status can be an option. So if that, is kind of ringing a bell, I would definitely recommend a consultation with an attorney. U visas are for victims of crimes, mostly violent crimes. So if you've been a victim of a crime in the US, it's worth consulting with an immigration attorney. Trafficking visas are for victims of human trafficking, as the name suggests. And so if you've ever not been paid for work or incurred debt in your travel to the US that you were required to pay back, maybe under onerous terms, maybe not, it's worth consulting with an attorney. And lastly is Violence Against Women Act relief, called VAWA usually for short. And this is for people who are married to and or the child or parent of a U.S. citizen or resident who is abusive. And so isn't extending the immigration protection they could to this person, right? A spouse can petition for you, but if they're abusive and not doing that, then that may be an option for you. And that's really the big for humanitarian relief under immigration law. And so in the slide that Megan had that said, one of the options is to petition USCIS to change your status. There's very little option to just change it to like, I want to stay here. So that's more like if you were already a student and like she mentioned, you're continuing your studies or you're being sponsored by an employer or this kind of thing, that's kind of one way. But other than that, you're really looking at these things. And I didn't know where to stick this, but this is as good a place as any. In Massachusetts, marijuana is legal, right? Cool, not cool, however you feel about it, it's a fact. But it's not legal federally. And so if the federal government, the immigration service, right, USCIS or the immigration court or whoever you may be dealing with in immigration, depending on your particular situation, were aware of that you are doing things that are legal in Massachusetts, like growing for personal use or whatever it may be, you could find yourself barred from some immigration relief or some immigration options because even though it's legal in Massachusetts, it's illegal federally, and so they do not care. So I warn about this because many dispensaries ask for ID to buy, as they should, right? So you have to be a certain age, but using your passport from back home is not the thing to do. Or really to show any ID at the dispensary. And now there's actually literally a record of you breaking federal law. So just FYI, there was no obvious place to put that, but it's important to remember it. And then we had gotten some just questions that folks had sent in. So I thought I would go into some of them. Some were a little bit vague. And so if this is your question and I'm not answering, feel free to follow up or, to ask more questions. I think at the end, they're making room for that. And so one of the questions was, when changing status, what are they looking for? What are red flags? And so again, that depends because you can't just change status to whatever you want. You have to be on one of these paths to change status, to from like tourist to student, maybe one kind of student to another, maybe from student to, an employee if you have a sponsor or a family member petitioning for you, this kind of thing. Okay. But I think the main thing to remember at those points, however, of these, if you're able to go about them, is that this is a moment that you're asking kind of for admission again. It's always a great time for immigration to kind of look at everything again. And so that's always a moment of risk for that reason, right? If there's been any issue or crime, or if there was an inaccuracy in a prior application that can be seen as fraud, that's always a moment that it can surface and be a problem. So it's kind of the main thing I wanted to talk about there. I think someone asked too, as an international student when traveling, and again, I don't deal with student issues a lot because schools generally have cool people like Megan to do that. And also because I've worked in nonprofit almost my entire legal career. And so we just don't see that many college students. But again, whenever you travel, whatever status you're in that isn't being a US citizen, when you come back, you're generally asking for admission again. You're asking to be readmitted. And whenever you seek admission, the US can look at all the inadmissibility grounds and decide whether you're admissible or not. So, when traveling, I think you just remember that, especially if you've had a legal problem recently and you have something pending in court, or if you went home and got in trouble, maybe while you were home celebrating whatever it was and came back, then you're seeking admission, and that's a point of risk to kind of like get that status change. There was a question about dual citizenship, and most immigration forms ask about all your citizenships. So it's hard to like hide the ball on whether you have another citizenship or not. And it's a double-edged sword because, which I think, again, being Venezuelan, I have like this unusually large sample from Venezuela, but a great example of that is many Venezuelans have dual citizenship with European countries because Venezuela was an immigrant hub, kind of like how the US was after World War II. And so many Venezuelans have derived Italian and Spanish and Portuguese citizenship from grandparents and things like that. And so many found it easier to enter the US who was on the lookout for this diaspora at the border by using one of these other passports. But that may now make it difficult to seek TPS protection as a Venezuelan for some of the people who did that. So the double-edged sword with dual citizenship is if you present one citizenship to benefit, it's hard to then switch to a different citizenship for a different benefit. But that's rare, so I wouldn't sweat it too much. And generally, they just they still know all the places you're from because most forms ask that information. I think that's all I had for questions that looked like they were for me. But I think that there's room for questions here. And yeah, that's what I have.
Perfect. Thank you so much. And so we do have another question. What can undocumented students do right now? Should we apply for DACA?
If you qualify for DACA, you should. The requirement, if you're like DACA requirements, they'll all come up. And so the main thing is that DACA is now, I believe, 14 years old. And so you had to have been in the country on the day DACA is announced, just like TPS. All these things are like this. They don't want like, oh, now there's this protection, I'll fly to the US. You had to be in here when it was announced. So that was, whatever, 14 years ago, 2012 maybe. And so if you weren't in the US by that date that I have never memorized in all this time, then you should apply. And if you weren't, you can't, even if you meet the other things, right? So you could look like the other DACA types and have come in a year later and you don't qualify. But if you look at those requirements and you think, yeah, I do qualify, then absolutely, I would recommend that you seek help. And places like where I work, so we can help people with low income. Most students have low income. I had very low income when I was a student. So there are places to help. There is a lot of self-help on the internet, and I'm sure anyone who's watching this who is eligible for DACA is very bright and could probably sort it out. But if you can get help, do that.
Okay. And then I think this one would be more so for Megan. Like what are the typical challenges that you might see an international student run into with obtaining their status, or if they're taking longer than expected to complete their degree?
Yeah, sure. Sometimes people come in, you see this a lot, people come in with a certain idea of what they want to study, and then they might decide to change majors, right? So as long as you are communicating with your academic advisor and the DSO, you do have the option, you are allowed to seek a program extension. Right. So you shouldn't feel trapped if you've picked a certain path and then you decide, oh, wait a second, this isn't what I want to consider this. As long as you have the conversation ahead of time, that option may very well be available to you. Where students run into trouble, perhaps, is if they withdraw from classes without telling the appropriate people, because to maintain status, you have to maintain a certain number of credit hours. And so those decisions, if you fail a class, you want to withdraw from a class, those are all, again, conversations you should be having with your academic advisor, but also the DSO to make sure that we can get you into something else so that you do maintain your status. So those are two that are pretty common that come up regularly.
And then I guess just like a last piece to kind of close out the session would be, what advice do both of you have for students or folks who are worried about like what's next? What does this degree mean if they don't have whether it's like the status or whether they can't get that employer sponsorship to work in the US?
I guess I would start by saying that consult an attorney, which is like the lawyerist thing ever to say, but it's true. So consult an attorney because you never know. A great example of this is I do a lot of LGBT asylum, which is why I often use it as an example, but a lot of people, many clients who I've represented in LGBTQ asylum just didn't realize that that was a ground because it's often called political asylum, for example. And so, you know, there's lots of other things maybe you don't know. And so it's good to just ask, you know, and have a consultation, just like a lot of what looks like trafficking or could be trafficking is sometimes unexpected. And so I mean, that would be the first thing I would say is consult. As far as employers, you know, I don't know as much like if that was kind of the avenue that you had and it was foreclosed. I know a lot of people ended up in that position in COVID because, you know, maybe offers that were going to or you felt were going to be extended and so forth didn't work out. And I'm less informed on that. I don't know if Megan, you might have something to add on that ground, on that area.
Yeah, no, I mean, my suggestion is similar in the sense of if you're unsure, seek clarification, right? Go speak to someone on campus and ask those questions, get the answers that you need in order to make the right decisions. As far as some of the employment sort of OPT options, there were certain concessions that were made in COVID. And some of the normal restrictions were lifted. We're hoping that some of those restrictions may continue to be lifted and removed permanently. We're sort of waiting to see. But I think, like Dayanna said, I'm not necessarily holding my breath on any of that. It is difficult to go from an F1 visa to an employment H1 type visa. It's not impossible. We've just been working with someone who's in that process now. But again, you know, that individual should also be working with an attorney on the side too. So yes, reach out, ask those questions, ask for clarification. Please know that we want to see you be successful at Regis. We want to see you complete your program here. And, you know, we invite and actively welcome all of our international students to be engaged on campus because we value their contributions.
Mm-hmm. I want to thank both of you so much for dedicating your time to do this event for us. This is all super important information, and I think a lot of folks will find it useful, not only students, but staff and working with students and supporting them. So we're going to close out for today. So thank you both so much, and thanks to all of you who joined us today.
Thank you.
Okay.